Welcome. I'm Ada Kay, your deaf courtroom commentator, breaking down the gripping courtroom drama, providing ASL interpretation when possible, while making justice accessible to everyone. Grab your favorite cup of Java and let's dive in.
Hello and good evening, everybody. I hope this finds you this evening. I hope that was a wonderful Wednesday. It is Wednesday the 17th. Yay! And I had a good day. We were watched 2 trials today and have been very, very, very busy. But the good news is I got my Rodecaster Pro 2 replaced. And I hope the sound is so much better for everyone. Hi, Miss June. Hi, Miss Deborah. Hi, Miss Linda Long. I'm sorry, I've got contacts that are still working on them. They're not quite there yet. And hi, and welcome to everybody. Welcome, welcome. I'm going to give a minute for people to hop on. I just got off of one live, and now we're going to the other. So I've been live for 10 hours today. Let's see what the total is by the end of as some of you may have heard, we've had yet another shooting. 3 officers have been or deceased in North Cororas Township. I'm bad at the words. Police Department. We honored the 5. 3 are deceased. 2 are in critical condition. 2 were taken straight back into surgery. So our hearts and prayers go out with the family first and foremost, their friends, their coworkers, and the community as a whole. For those of you who don't know me, I am Ada Kay. I live in Kerrville, Texas. Yes, that is where the flood was. And I do understand tragedy. Heart goes out to everybody. So I'm going to give a minute for people to hop on because we have got something. Miss Donna Adelson has decided. Hey, sweet Magnolia 15. How is my sound? I need a mod monitor sound. I need to know if it's clear, crisp, and a good volume. Like I said, we have a brand new Rodecaster Pro sound machine, and it may be a little bit soft, so I'll turn it just a hair because I'm nodding. Okay, so we have Donna Adelson putting up a motion for a new trial. Y'all, when I saw some of the stuff that was happening after trial with the TikTok people and the jurors, all of that kind of stuff, TikTok juror, another juror, and all that kind of stuff, I knew this is what they were going to grab on. Y'all, they grabbed on with everything they had, and they're fighting for a new trial. So, yes, we're going to go ahead and start jumping in. I'm going to have to do some maneuvering, if you don't mind a minute, because I'm going to have to move this over here. I'm going to have to put my notes in front of me. I'm not used to this pattern, so we'll see how it goes. I am in live comm for my mods. Just mods, so you know, my StreamYard's over here, Discord's over here. Content is in front of me. This is a little different from what I'm used to doing. So we're going to be, I can't, there we go. I guess I'm going to have to do it like this. Give me a split second. I'm going to have to finagle it just a little bit. I don't like it, but I want to do it. There we go. That'll do. Not ideal, but it will There we go. Okay, how are you? Good. I mean, is it really that different? I had somebody message me and say, "Oh my, your sound is like so professional now." I'm like, I had the same device. Mine was going bad. So I got to send it back. And so I am so happy that the sound is good. June, my sound, are you happy with it? Um, Let me know in conversation. All right. Y'all ready? I almost want to play soft music in the background while we do this, but then you may not be able to hear me. And I don't want to confuse y'all. So we'll just do it this way. I thought I'd have fun, but I maybe too much. Okay. In the circuit court of the second, I love how they do this. In the circuit court of the Second Circuit and in the Leon County of Florida. There we go. Here we go, y'all. All right. Get me centered. Get me comfortable. I was getting my feet up. I get comfortable. Here we go. Here comes the defendant's motion for a new trial for the lead to interview jurors. Now, I'm not going to read every single word of this because there are 18 pages and I've got about 10 pages of notes. So what I'm going to do is I will be giving summaries and I won't be reading every single word. So I always want to cry juror misconduct and guilty verdict must have been. Yep, they do. Miss June, I'm going to let you take over chat. All right, here we go. Defendant Donna S. Adelson, by through an undersigned counsel pursuant to Florida Rules Criminal Procedure 3.575, 3.58, 3.600, parenthesis A, parenthesis B, 2, and 3.600B, parenthesis 4, parenthesis blah, 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 cited. After I do that once, I don't do it again. I just tell you it's cited. Respectfully request that the court grant a new trial and support thereof states as follows. Oh, is my thing up, Miss June? There we go. My bad. I forgot to put it up. Thank you, thank you, thank you. Your home state, Deborah, I'm so sorry. A jury convicted Miss Adelson as charged in the indictment September 4th of 2025. The motion is timely filed within the 10 days of the rendition of the verdict pursuant to Rule 3, period 57 and 3590A. Ms. Adelson requests a leave to interview juror number 5 and juror number 7. Ms. Adelson files this motion for a new trial on the following grounds. 1. Juror misconduct. 2. Verdict is contrary to the law, weight of evidence. Bitch, please. Yep, it's after 5. I'll say it. The court erred in decision of any matters of law which arose during the trial. What? The court, I wanted to read this raw with you guys. This part, I read a lot of other parts. I didn't. The court erred in a decision of any matter of law which are you kidding me? Wow. And number 4, other cause not due Miss Adelson's fault. She did not receive fair and impartial trial. In other words, blah, 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 wah, 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 wah. Motion to leave to interview juror. Court preliminary instructions to the jury, the standard instructions were read. You're not permitted to communicate about this case to anyone, including your spouse, family members, friends, neighbors, and even your fellow jurors. No communication, no in-person telegraphic or electronic communications, such as emails, text messages, post information on social media in bold, or a website or any other form of communication. We'll get into that one in a minute. You're welcome. Supplement
Subsequent to the trial, juror number 7 went viral on TikTok concerning her jury service. She revealed that she posted to TikTok during the trial. In reviewing the juror number 7's TikTok account, the undersigned identified she posted on TikTok that she was selected as a juror on August 26, 25. A flash drive with the video will be provided to the court. As the undersigned has been informed, that particular TikTok was deleted by the juror from her account. The undersigned seeks to interview juror number 7 concerning her social media activity during the trial. All right, let's talk about number 7. The core and factual basis alleged in this motion, which is very high. This, out of everything, juror number 7, and we'll talk more about them in a minute. Juror number 7, this is the best hope for her out of everything that they filed. You might as well just throw crap at the wall, but this one may stick. Juror misconduct. Juror number 7 allegedly had posted TikTok mid-trial and later deleted the post. Juror number 5 gave a post-verdict broadcast. Okay, let's talk about juror number 5. But juror number 7, here's the thing. If she posted that, if she has a TikTok page and she's posting she's going out and eating pizza with friends while she's a juror, that's fine. She can post whatever she wants. She just cannot post anything about the trial. The fact that she posted she was a juror, if she just said, I got selected for jury duty and did not disclose the name and case and the nature of the case, then she may be fine. But if she posted that she was in the Donna Adelson trial, that may be a problem, boo. And that to me is where this is where everything's going to get interesting. Everything's going to get interesting on juror number 7. Juror number 5 appeared on a podcast, Surviving the Survivor. During his appearance, he revealed he considered how Miss Adelson reacted to the evidence and the testimony admitted during the trial. Although he subsequently stated he obviously did not consider during deliberations that he considered Miss Adelson's reaction whatsoever is concerning, as her reactions are not evidence and are extrinsic or external rather than that it was adheres to the verdict. Okay. He considered her reaction. Every time I sit across from anybody, I could be sitting across from June, Pink, Angela, any of my mods in a meeting, and I notice their reaction. You automatically consider those actions at the time that the actions are being given. That is called body language. That is how we gauge how someone is responding to what we're saying. Now, does that mean I'm going to take that reaction and use that if I have to make a decision to release one of them or fire them? Not necessarily. I don't think that particular argument holds a lot of weight. As long as he did not consider it for the deliberation and decision making. I think if we keep it separate, I don't think that's a problem. I'm not a lawyer, never claimed to be a lawyer, but boo. At least that's my opinion. Okay. So because of the above, undersigned seeks to interview juror number 7 and juror number 5. Okay, I'm going to go through this real quick. Stop. Okay. So juror number 5 gave the post-verdict podcast interview describing how he observed and considered the defendant's facial expressions during the trial. Jurors bias courtroom environment. The motion accesses the trial judge of favoring the prosecution and allowing gallery behavior that may have been influencing the jurors. Evidentiary rulings and weight of evidence. The defense contends important evidence was improperly excluded or turn-coded, planned. I'm just saw something pop, sorry. And that the verdict is contrary to the evidence. So on juror number 7,
I just struggle a little bit with juror number 7. When I saw them do what they did, that concerned me a whole lot. The defense is seeking permission to do several things. One, interview the juror about the social media activity during the trial, and then whether she could assess or share information or otherwise violated the jury's instructions. So they want a bite at that apple. They want to basically voir dire her and figure out, did she or did she not break the rule of the jury rule? I don't think she did, but I did not see that particular piece of evidence in which they are citing that has later been taken down. What I did see, I had no problem with because she was no longer a juror at the time, and she's making the most of her 15 minutes of fame, in my humble opinion. They have not had the hearing. Did they have a hearing and saying that both sides? I think so. I don't recall, to be honest, June. If you want to Google that and let me know, that'd be great. Ooh, right. I forgot about the juror debacle during trial. Yeah, I think it was. I think it was her. You're refreshing my memory. Thank you. Now, the podcast, a juror that appeared in podcast number 5, Surviving the Survivor, is described that he considered the reaction to the evidence. The defense says the juror was told not to consider defensive reaction and that such comments are improper. Now we're going to talk about the judge's bias. Let's go down a little bit further. I'm not going to read every single word of this. I'm sure y'all, if you want to, you can go to Seeking Justice and download this. So let's go up here real quick. I do want to read this. It's important. Number 10. According to the Florida Supreme Court, potentially harmful juror misconduct is presumptuary prejudicial. I have a hard time with that word. Parting to seek a jury interview does not have to conclusively establish that the alleged juror's misconduct occurred and actually prejudiced the case. It is only necessary that the party establish bias for an inquiry or grounds to party believes may have existed. Once improper conduct or juror misconduct is established by a juror interview, the moving party is entitled to a new trial unless the opposing party can demonstrate that there is no reasonable possibility that the juror's misconduct affected the verdict. This number 11 right here is going to be the entire basis for this motion. Number 1, did the juror have a bias? We'll go up again. There we go. If there was misconduct by the juror, or there was prejudice in this case in any way, then the defense would have to prove it didn't affect the verdict. If they cannot do that, then Donna Adelson has a good chance of a retrial. She really, really does. Shockingly, Donna Adelson has a chance for a retrial in this case on that account. And I forgot to. I'm sorry, y'all. I do not believe hold on. I don't know why. I don't know why I can't. My Facebook thing is acting up. I don't know, y'all. I don't know. I can't. Won't let me do it. Okay, my apologies. I had someone reaching out to me in Facebook wanting to be able to see this, and they can't. So Once the improper context of juror misconduct is established by the juror's interview, that is where this decision is going to be made. One, was there misconduct by the juror? Number two, is it remediable? Would it affect the verdict in the end? That is the big question. If a juror's misconduct is confirmed in the juror interviews, the undersigned will request leave to make more extensive arguments concerning why the juror's misconduct in this case warranted. And the verdict is contrary to the law that weighs evidence. I really don't want to go too much into that, so we'll just go over my notes. I'm not going to read word for word because, do you know what? It's something that everybody uses. Not going to. This motion alleges the repeated conduct by the judge demonstrates favoritism towards the prosecution. Example reported, including ganging up, granting setup time to the state, and jocular behavior, limiting defense time and decide whether defendant should testify. Oh, and gallery behavior that drew jurors' attention. The motion asked the court to consider whether the judge's conduct contributed to the unfair trial. Really? Oh, no. So, do y'all remember in the trial that the biggest part of this, and we knew that this would probably be on their appellate issues, is when she was wanting to have more time to decide whether to testify, and he kept giving her 5 minutes, kept giving her 5 minutes, kept giving her 5 minutes, and then she kept going and going and going. Oh my gosh, y'all, that is why that's in here, right here. And I think that he was very, very patient with her, and the fact that they knew from day one of this that she was going to have to make the decision whether to testify or not. And it is in my humble belief, that Donna wanted to testify. Donna wanted to testify. But her lawyers were saying, babe, you're going to cook your goose even worse. I don't think her lawyer actually listened to any of the podcasts because that's what's mentioned is not how it happened. All of the lawyers I've listened to said that she's throwing spaghetti at the wall. G14, she is throwing spaghetti at the wall. Definitely is throwing spaghetti at the wall. Guys, please share this. Get this out to everybody. Please share. This is a layman's term. I am not a lawyer. I'm not. I'm just going through it as if, and if I was a juror or somebody out in the gallery. The defense is arguing the key evidence or exhibits were improperly limited. The partial admission of the planners rather than the full planner itself is one of the key issues. Jailhouse informant credibility problem and overall verdict is against the weight of the evidence. There are asserted as independent bases for the new trial. Yeah, I don't think that's going to fly. Now, the governing law, what the court must consider. I'm going to get a sip real quick. I've been wearing red all day. My straw's red. In reality, she had 24 hours where did June go? Angela, June went bye-bye. Okay, will you do me a favor, Angela, and start popping up comments because it's on another monitor because I got all the other stuff in front of me. She did have 24 hours, and if she wouldn't have come back the next morning and said she changed her mind, just ever wouldn't have let her testify. You're right. Oh, you're driving. Be safe, G14. Be safe. Whew, I'm getting hot. That I got a nice. So, Georgia didn't sleep the night before because she expected Donna to. Yes. Yeah. The governing law on this, on the misconduct order, no impeachment rule and juror testimony limits.
Federal Rule 606 of the Florida Evidence Rules broadly restricts jurors' testimonies about the internal deliberations. A juror cannot be examined about why they voted a certain way. Period. Law. But it is permitted to have an inquiry whether there was extraneous prejudicial information, outside influences, bribery, or threats, or whether a juror lied during the voir dire about material matters. See Rule 606 of the Florida Commentary and the Post-Judicial Juror Inquiries. Now, we won't go there, but I'm giving you the numbers in case you would like to see it yourself. Standard for granting a new trial on a juror's misconduct, Florida law, and the appellate cases that the motion will be judged against required a showing that there is a reasonable possibility. Here's the key words: reasonable possibility the juror's misconduct affected the verdict. Trial courts have broad discretion, and appellate reviews is abuse of discretion. That is the usual phrase the court is going to use. Oh, judge would have definitely allowed her to testify. Voir dire dishonesty. If a juror intentionally misleads the court during a voir dire about material facts, i.e., pretrial biases, exposures to disqualifying information, that can be powerful grounds for a new trial. Such cases, De La Rosa and other Florida proceedings. But the defense must show material misrepresentation and prejudice. That is very hard. It's like also sitting there saying, I'm going to get you on, oh God, when is it when you lie in court? My brain's gone. But anyway, it's very hard to prove that somebody lied on the witness stand, because if they believe what they're saying is true, even if it's not true, if they believe it at the time they say it is true perjury. Thank you, Angela. So it's very hard to get somebody like Wendy Adelson. It's hard to get her for perjury because you have to prove that she knew she was lying and she had the intent to lie. That is why perjury is so hard to prove. The strengths of this motion. Let's see what potentially can work. The social media posted during the trial is a strong factual hook. If a juror who posts publicly during a trial, especially the foreperson, if that is accurate, can be viewed as having violated the court's express instructions. If the post contained or solicit outside content or showed the juror discussing the case with outsiders. This is, oh, hi, kitty. Somebody's at my feet. Startled me. That is classic extraneous influence. If the defense can preserve a deleted post, so if that post was deleted and they can pull it up and prove it, we may have a chance here for them. Okay. Okay, on number 17, the Florida courts have upheld multiple times that when considering a motion for new trial under Rule 606.3.600A2, based on the claim that the verdict is against the weight of evidence. Nope, we've already done that. The weight of evidence, we'll get to that a little later. Let me get right here. So now let's look at them individually. Post-verdict public comments by a juror about a non-evidentiary matters are legally sufficient if they show exposure, external information, or clear misconduct. If juror number 5 podcast statements can be shown to reveal reliance on a non-trial information,
or improper sources. That is an extra matter that may justify further inquiry. Meaning, they can prove that juror number 5 was influenced by outside forces and or behavior or internal forces that they should not be considering while making up their minds whether it's guilt or not guilt. That could be a problem. Voir dire dishonesty, if proved, is particularly a strong base facts. So if the juror lied about a prior knowledge or exposure or bias during a voir dire, Florida proceeding treat this as a prejudicial misconduct because it prevents the defense from exercising a challenge. Substantial proof of mistrial falsehood will get the court's attention. Yep, that's going to be a little bit interesting. I'm sorry, I got a little distraction down here. Hi, everybody. Hi, Out and About with Diane. So the weakness and the hurdles for the defense over this with the jurors that they're going to face right now is the no impeachment rule limits what a juror can be asked. The court will not permit an inquiry into subjective thoughts, processes, or internal deliberations. So, if the juror podcast simply revealed that the juror felt something or thought about the defendant's expression, that testimony may be treated as inherent into the verdict and therefore no proper basis or biases for impeachment in the verdict under Rule 606 in Florida law. The defense must focus on the question on eccentric matters, post contrast, external evidence. They have to focus on that. Deleting the social media post is harder to prove without forensic preservation. Now, they say they have a screenshot or they actually have a copy of this post that's no longer there. The news report indicate TikTok post was deleted. If the defense cannot produce a preserved copy or a third-party archive, the allegation may be too speculative. The course often requires some corroboration of deletion claims before permitting a broad juror interrogation. Yeah, that's going to be fun. So this is going to be where subpoenas are going to have to come into play. Sorry, the contact's moving. Subpoenas are going to have to come into play, and they're going to have to get a copy. Boy, it is moving. There. They're going to have to get a copy of that deleted TikTok, if they even can. Judicial bias claims are fact specific, are very hard to win. Accusations that a judge favored the prosecution requires concrete examples showing the judge conduct created a real or probable bias over deprive the defendant of a fair trial. Courts tend to give judges wide latitude for in-court management. Defense must tie specific comments and rulings that were on the record to being prejudiced. Have to. So let's go back over here for a minute. The trial courts act as a safety valve by granting new trials where evidence is technically sufficient to prove criminal charge, but the weight of the evidence does not appear to support the jury verdict. When determining the weight of evidence, it is essence the trial court acts as a safety valve by granting new trials where evidence is technically sufficient to prove that a criminal charge, but the weight of evidence does not appear to support the jury verdict. They're saying that the evidence showed in court does not match the weight of the jury's verdict, meaning the jury got it wrong, boo. We disagree. Oh, I'm out of camera. Tell me I'm out of camera. Meaning, y'all should have yelled at me, out of camera, girl. Oh, thank you, June. Sorry about that, June. So when determining the weight of evidence, that is going to be very difficult in this case. I don't know what, Matt, is that you? Hope the cats aren't getting ready to fight. Trying to introduce a new cat to the household is scary. At this stage, the courts must make a finding that Patricia Byrd was credible before considering Miss Adelson's alleged confession to Byrd. Under no set of circumstances can Byrd be considered credible. That's one of the ladies in jail that was in jail, another fellow inmate turned witness. She testified the defense investigator with whom she spoke was a white woman. Dawn was obviously not white. Maybe she's colorblind, boo. Let me see. All right, we're going to pause there because I'm getting ahead of myself. I took notes, and it's kind of hard. It's kind of hard to do this. Let's go to technical evidentiary set. Motion should be probably does not request. Why does it matter? Is monkey butt not? That may be monkey butt playing, actually. So one thing that we need to talk about is preserving the subpoena social media content. I did skip that. My apologies. Let's back up. Demand by any, they can subpoena TikTok and demand any deleted post, account media, any metadata, timestamps, IP logins, and ask TikTok to preserve the copy or third-party archival. Deleted posts can sometimes be reconstructed from a platform backup or cached copies. A preserved post is the linchpin for proving the actual trial social media violation. This is going to be the vital point right there. This is going to either make it or break it for her, is that post. Subpoena podcast producers request audio transcripts for juror number 5. Now, we have seen it. It is still there, so they can get that evidence pretty easy. Also, they can request the video cast from Court TV and any other gallery footage to show behaviors within the courtroom. Jurors can see them and potential external influence. The sworn affidavits in the court-ordered juror interview, if focused narrowly on whether the jurors access external information, B, whether the juror discussed the case with anyone, and C, whether anything or anyone outside the jury room attempted to influence the juror, bribery or threats, for example, and D, whether the juror answered voir dire questions truthfully. The defense must avoid questions about mental processes and what's happening in deliberation. Those are barred. If the eccentric evidence is shown, the court applies the reasonable possibility test. Could the misconduct reasonably have affected the verdict? If yes, new trial is granted. If no, it's denied. Bottom line, short version, the defense has arguably presented enough to force a limited judicial inquiry. That is what my understanding of this is, that there is just enough information for a limited judicial inquiry. For example, the judge will likely permit at least a targeted juror interview or evidentiary hearing. Whether that inquiry results in a new trial depends on the hard proof. Preserved social media content, corroborating witnesses, or even evidence jurors lied about the voir dire. Without such corroboration, court will deny the new trial request, even when a juror commits an unsavory. Hello, Natasha X. Hello, Deborah, Angela, all of y'all. Thank y'all for joining. So let's look at the quick checklist that the defense could complete immediately if they haven't already. They will need to get TikTok information. So subpoenas for TikTok for the deleted post and account MD metadata. They have to obtain and preserve all video or courtroom live stream video broadcasts, raw files, They have to subpoena the podcast hosts themselves and the recordings and any notes. Find a motion of a juror. It's a long day, guys. I've been live for 11 hours. File a motion for juror interview in camera hearing, narrowly tailored, and attach any affidavit witness statement. If a juror's dishonesty in a voir dire is alleged, collect the voir dire transcripts and compare it with the juror's statements. So here's a quick citation for the controlling law and useful particular pieces. So in post-trial jury inquiry decisions, Florida Bar in particular, Rule 606, no impeachment rule re-jury testimony. Okay, practitioner academic pieces on jurors, interviews, and versus inherent matters. Florida precedent on the reasonable possibility standard. That is where everything's going to fall. Was it reasonable, and is there reasonable possibility of blank? So I want to look a little bit at the arguments for the defense. Juror number 7 alleged TikTok postings during the trial violated explicit court instructions not to use social media. This is extenuous information under the Florida law, which allows inquiry when a juror is exposed to outside influences. Juror number 5 podcast commits that comments are considered Donna Adelson's facial expression shows reliance on nonverbal evidentiary factors, which jurors are instructed not to use in deliberation. So I can't watch a juror's behavior. Even remember the not the jurors, the defendant. Remember the defendant that jumped over the judge's podium and attacked her? If I'm on the jury, I can't use that against him. That would be hard not to do. So the counterpoints for the state are comments about demeanor or reactions are part of jurors' natural observation, not an extrinsic evidence. They are inherent in the verdict, cannot be used to impeach. Deleted TikTok posts without proof is speculative. Court required concrete evidence before granting the interview. So now we're going to get into the court of the claim, the arguments that the courtroom bias and the gallery influences. A defendant is entitled to a trial free of bias and outside influence. The judge allegedly allowed the gallery to behave visible to the jury. Plus, and I call BS, repeatedly favored the state procedurally, set up time and rulings. This can create a structural error, undermining the appearance of impartiality. All right, show of hands. How many of you think this is actually true? I remember him standing up, and I remember Donna Adelson's attorney making comments about how he could hear people behind him commenting and making faces. And I wanted to look at him and go, dude, do you have eyes in the back of your head? How in the hell are you seeing them from behind you make faces? You may hear shuffling, you may hear noises, but you have reporters who had papers, you had people taking notes. I mean, come on now. I think he did what he did, created a drama that wasn't there in hopes of having it for this purpose and this purpose alone, the appeal. I mean, we had view of the jury quite frequently. Did any of you guys see any problem with the juror? I mean, not the jury, the gallery. Did you see anybody in the gallery acting up? No. I think Donna was more animated than anybody else. The trial, the counterpoint for this on the state side, their response will be something along the lines of, trial judge have wide discretion to manage their courtrooms unless the defendant can prove actual prejudice, i.e. juror admitting they were swayed by spectators. appellate courts generally uphold the verdict. So now here's what the law says about this new trial motion argument for the defense. The Florida law allows new trials where juror misconduct, external influence, or dishonest voir dire response create reasonable possibility prejudice. Motions must be filed promptly, which this defense did. If the court finds an extrinsic influence or false voir dire answers, the new trial is required to protect the constitutional rights. But for the state's argument, no impeachment rule bars inquiry into the deliberation or thoughts of the process. Jurors' interviews are rare and only allowed when strong evidence of external influence exists. Your speculation is not enough. So what happens next in the court? Well, the judge for the defense, they're going to argue to grant a leave to interview the jurors narrowly, focusing only on extrinsic, I have a hard time with that, influence, social media, outside content, dishonesty, and voir dire. If the jury confirms the misconduct, the court must set aside the verdict and order a new trial to preserve due process, which means we get another bite at Donna Adelson. Ooh, I wonder if she would, hey, if we got a new trial, do you think she'd testify this time? I do. I think she very well might. So, the state's counterpoint is the motion is an attempt to relitigate a case that is for lawful conviction without preserved evidence of misconduct, screenshots, affidavits, and other requests for juror interview. She did not. That is this case in a nutshell. That is all of this in a nutshell. So I do not wish to read this entire document. It is quite extensive, but you can get it over on Discord at Facts, Truth, Seeking Justice Discord. You too can get these if you wish. There we go. One of the things that really gets me is that she really believed that the judge was mistreating her in this trial. The judge was inappropriate. What are your thoughts? Do you believe that this judge acted inappropriately in any way, shape, or form? I felt that he was very fair to her. In fact, more fair than most judges would be. I thought that this judge had a whole lot more patience, by far, patience. Y'all, I'm by far more patient. I couldn't. I'd be calling her out left and right 7 ways from Sunday on this because she was an absolute difficult one. I think Sarah Boone was more difficult than she was in my own opinion. In my honest opinion, I think Sarah Boone was more difficult, but Sarah Boone wanted to represent herself. So there you go. There you go. It's not true. No way. Thank you, Angela. Oh, thank you guys so much for joining. We did, and I thought about it, and I'm being very careful because we do have the list of, we do have, where are you? Oh, that's right. She's down here in appeals. Where's Donna Adelson? Did we move her file, June? Because I don't see her in case. I don't see her in appeals. Is she in archive? Why can't I find her? I see. Sentencing, thank you. I don't even see that. June, just FYI, in my Discord. Okay, Hold on. I gotta fix it. I didn't have permissions for my own one. Hold on. Okay. So we had a bunch of documents that dropped today, and I'm pulling some of them up. One of them of which was the witness list for the state, witness list for the defense, the verdict form that was filled out, planted today, but we also had the witness list, and I'm not going to show. I don't know, June. What do y'all think? Should I show the witness list? I don't know if I feel comfortable. I don't feel comfortable showing the witness. I mean the juror list. Witness. I don't care about the witness. The list of jurors. I do not wish. I don't think I wish to show the list of jurors for multiple reasons, one of which is their privacy. But there is a juror list, and we have 1, 2, 3, 4, 5, 6, 6 men, and the rest were women. 6 men, and the rest were women. So that's interesting. I'm looking at their form. Total of 180 prospective jurors. Jury plus alternates were 14. They had 17 challenges, 76 excluded, and 73 not called. That's a pretty decent number. Actually, 73 out of them were not called because, well, they got their jury in time. He was stern, but no nonsense. He was more than fair and impartial. I agree. Sarah Boone was there. Yes, but her judge was a saint. I mean, he got Judge of the Year for our channel. Oh, by the way, starting in December, we will be voting for our channel Judge of the Year. So if you want to nominate a judge, you may nominate a judge. We will hold an election, and at the end of the year, I'll send a little plaque thing to the judge, voting them Judge of the Year for our channel. I thought I'd do that. So if y'all are interested in that, let me know. Maybe we ought to set up a Judge of the Year thing. Discord, find a way for people to nominate Judge of the Year. But that would be amazing. I did it last year, and it was Sarah Boone Judge, and I can't think of his name to save my life. He got Judge of the Year last year. Our first holiday season together as a family. So what did you think? What were your opinions? What was your thoughts on this? Would love to know. Pulling up. I am also going to be doing a dive in a new case coming up. Okay, I'm just getting everything closed down that I don't need. Again, our hearts and thoughts and prayer go with the families that are affected by the shooting. 5 police officers, 3 of which have passed away. 2 of them are in critical condition at this time. Oh, that's okay, Deborah. We're kind of winding down. I wanted to try to keep this to an hour because I now have been live over 11 hours today. And I want to do a movie night maybe. A movie up. I enjoy them. I lay down, relax. I may go to sleep tonight though. If I don't respond at the end of the movie, just put it because I'm asleep. Be nice to go to sleep before 2 a.m. for change. I don't go to sleep since we started the move a week and two. Now this has been almost a week and a half ago. We were doing the move. We finished this past Sunday. Can't go. Oh, you, June. You're so freaking amazing. And remember, chat, there is Judge of the Year. We need to put an emoji with it, but yes, we'll do that. Judge of the Year. Let me put emoji on there. Put this in a period. Let's see if I can find a judge. Judge. Then an award. Prize. Oh, how about trophy? Yep, we'll do that. I got you. And we got that up. Yep, we did it. So we got Judge of the Year set up. So we will start having people nominate the Judge of the Year. And y'all can go in and put a name of a judge in there, and we will narrow it down to the top 3. And we will do a vote probably mid-December. So everybody, I hope you enjoyed that. I hope it was good. I'm learning. I'm not a lawyer. I did my research. I worked all day on that. The moment that thing hit, I started working on it. So I hope to get better at it. But for me, I learned a lot. And the number one thing I think that the state needs to be concerned about is that juror who supposedly went on TikTok while being a juror and posted information. Now, I will say, I did hear an attorney, not the ones that we normally know, one I hadn't seen before, was up real late, and they said that the TikTok person would only be a problem if they saw anything concerning the case and if they posted anything concerning the case. Now, one of the things is that it says do not pay it, well, here's a good question for y'all. If it says you're not to watch news concerning the event, then which you are being a jury for? So say you're watching the weather part of the news. Say you know that the beginning part of the news is where all the drama happens. So you wait about halfway through, turn it on, and you're watching the weather. You want to get your weather news. Or you go online. Tells you how old I am. We did everything by the news. You go online and you type in the weather and say your favorite news station pops up. You click on the weather, and in that you see something on the case you're following. You have to tell the judge about it, but if you just saw it and clicked off so quick, you're not going to be kicked off the jury as long as it does not affect your ability to judge impartially. We have seen that happen in multiple trials this year where somebody has seen something. They went into a restaurant and it was on the news and they asked them to turn it off or they left. I mean, in this day and age, 100% being out away from it, unless they're sequestered and all TV, social media, telephones, and everything are taken away, it is going to happen. What's important, though, is what you saw. Did it or does it influence you to the point that it affects your verdict? Are you not able to set that aside and make a decision based solely on the evidence which has been presented to you in a court of law? So even if the TikToker saw something, and I don't know if she did, only thing I have seen of her is she did do a response and I watched it. And in that response, it was, I want to explain myself. I wish I could find that. Let me see. Let me see if I can find it. See if I can find it. I'm Googling it. I'm trying to see. Trying to find the woman. Let's see if this is it. Okay, let me get this going because it is with Court TV and I can share their stuff. So let me get this up and going. I didn't think of it earlier. Okay, here we go.
Donna's eldest son's testimony very convincing. She felt that. And of course, she was talking about Wendy Adelson. So why don't we go ahead and listen to what she had to say about Wendy?
Long story short, but also probably long at the same time. Yes. Yes, I do. And do I think she is next? Do I think Harvey might be next? Absolutely, I do. Now, the state hasn't said that specifically, but there's evidence showing that they were aware of what happened.
Now, she was also saying that she does not know how Wendy Adelson sleeps at night, saying that when Wendy was on the stand, when she was testifying and responding to questions, saying, I don't know and I don't recall, she said that points to guilt, in her opinion.
Yeah, in her opinion, and some people have questioned whether she was actually the foreperson. Kelly, I was inside of that courtroom, saw her rise when she said, yes, we have reached a verdict. That is indeed the jury foreperson.
You would know, Julia.
Wow. Young. I always pick for people as the old person, the grizzled one, but that was a very young foreperson.
There were several young people on this jury, so I was not surprised that she would be picked.
Went a lot of.
Okay. What is the name of the lady? What is her name?
Yes. Yes, I do. And do I think she is next? Do I think Harvey might be next?
I'm sorry, I've got several windows open. Do we know what the name of this TikTok girl is? Because I put it away. I put all the documents away. Let me go back over to documents. Let me find them. Go to Donna Adelson. Document. Nope. We do have the jury instructions. Verdict form. Okay, where's the verdict form? What is her name? I can't read it. Okay, I'm trying to find. Why am I having so much trouble finding it? I just had it. It had all the jurors listed on it. No, I don't want to create. I hate it when things don't work well. Here it is. Is her name JC Maxwell? Yes. Got it. Let me find. And let me go over here and find what I need to find. Give me all. I got it. Let's see if I can find her now. I want to see this video. I want to see it. I remember seeing just a part of it, and it was interesting. Well, there's nothing on there. Is all of her content down? Oh, there's so many of them. I can't even tell you. There's 20,000 of them. I can't find it. I'm trying to find the video where, yeah, but I found her name, but the problem is finding her video. Let me do this. Let me do it this way. Hold on. Would help if I could get my fingers on the right button. Gee, many Christmas. God knows I've thrown a Hail Mary full of grace. I've thrown a Hail Mary. I need the video itself. I can't even find her TikTok page. Because she talked about how. Okay, fine. We're going to do it the hard way. She talked about how she felt she could share this. She said that she did her research. It's totally blank, y'all. It was totally blank. Why was it blank? Maybe they took it down. They may have taken it down. Nope, here it is. Got it. Yes. I got it. Okay, now I need to find reply.
So I'm going to answer some questions now. I do want to preface, okay? For one, not a single member on the jury knew anything about this case before being selected to serve on the jury, okay? First and foremost. Number two, as far as people's concerns as to me being on social media and posting my TikToks in the last week or two, there was no rule stating that we cannot be on social media. The rule is provided by Judge Everett in this case, okay? We cannot seek out information about this case. We cannot talk about the case with anyone. We cannot listen to others talk about the case. We cannot do anything in regard to the case during the trial. But now that I'm released as a juror, I have the freedom to say and do whatever. But also in that regard, I don't watch the news. It's depressing. I haven't watched the news in years. If anything, I'll check my weather app, my little Apple weather app once a week just to see. My For You page on my TikTok, where I am the most active, is mostly like TikTok shop videos, like members of like the moms of TikTok community, because that is the content that I typically engage and interact with. I also post that sort of content sometimes, just like trendy, funny, like music videos, whatever else like that. Basically like stupid humor and then mom stuff. That's what I look for on social media. So I'm not breaking any rules. Along with that, I have time before court, during our 1 hour, at least minimum, lunch break during the days of the trial, and then after court to do as I will in regard to all of that. So no rules were broken. No rules are being broken now. I appreciate all of your guys' concern. I'm also going to prove that I was on the jury because there's some of you who's doubt it. Here is my appreciation letter from Mr. Stephen Everett, the judge on this case.
Okay, she does go on to prove that she was on the jury. Let's see what she says here.
Donna
Donna Adelson was found guilty on all 3 charges for killing her ex-son-in-law. I'm here to say that I was on the jury and I got to be the foreperson. If you have questions, let me know because I can finally talk. Donna Adelson was found.
Maybe I ought to reach out and see if she'll come on to my show after all this is said and done. I wouldn't do it now, but maybe I'll reach out. So that was her response to this whole thing. You see my mess. Thank you. Yep. Thank you so much for helping me find that, guys. You're so awesome. So she is right. After the fact, she can do whatever she wants. But the question is what did she do while being a jury? Now, if she went on and said, hey, I got jury duty, and that's it, nothing they can do. Hey, guess whose jury I'm on? Her first name begins with the D and the last one begins with an A. Don't think they can do much about it. Not enough for a new trial. But if she went on and actually talked about the case and being on the trial, that's a problem. So everything is going to totally hinge on the facts that are presented in the interview. I think that there's a 75% chance there'll be an interview concerning what was posted. I just don't think, though, this is enough to get her a new trial. What are your thoughts? Do you think this is going to get her a new trial? I don't. I think that, number one, when her attorney kept standing up in court and complaining about people in the background making faces and noises and doing all of that crazy, crazy stuff, I think all of that was setting up for this right here. He knew he was pretty much done. He knew that he was pretty much, guilty verdict. Lawyers know. They know what potentially is going to happen more often than not. And in her case, it was pretty much for a lot of people. But you never know what juries are going to do. We've had a jury that's a couple of times this year that surprised us. But yes, if there was a video where she said she was on the jury, or was she on a jury? That's going to be the key. That's going to be the key, because I know somebody who went online and said, hey guys, guess what? I got picked for a jury and it's a doozy. That's not enough to that's not enough to cause a new trial. I don't think it'll be enough. We did talk about that when we thought she might try counsel. Yeah, ineffective counsel. I can't believe they didn't even done. Well, that wouldn't be her, and that wouldn't be with that attorney. That would be another attorney. But the thing is, for me in all of this is that, number one, I don't see enough to cause a trial with the jury. Number two, as far as the judge is concerned, I thought he was the most patient, kind judge that they could have had. I was really at a point kind of like, y'all, I wouldn't be this patient. And when it comes to them being forced to set up and be faster and do all this stuff, I didn't see that. In fact, I saw them given time, especially I think it was closing arguments or something. They were given extra time. Hey, if you need more time to set up, no problem. I remember that. As far as given enough time for Donna to make the most important life decision she can in that moment, to testify or not testify, they, like the judge said to the lawyer, every client, every defendant gets to this point. Every defendant has to make this choice. This is not a surprise. And it is up to the counsel to get their client to a point that they make the decision. Am I going to testify or am I not going to testify? And that is a client and defendant and attorney conversation. And that decision has to be made, and it has to be made the court aware of that decision, because the court has to give them rights, make sure they're not being coerced and all that. It's like what I call a micro mini voir dire, and they did have that opportunity. And then the judge gave her 3 additional times, 5 extra minutes, 5 extra minutes, 5 extra minutes. And, the thing is that the day before he said, you guys got to let me know tomorrow. The day before that, he goes, y'all got to start thinking ahead now. We're getting to that time. He did. I'm paraphrasing, but he did. And now you turn around and you say, oh, we're not ready, Your Honor. We need more time. You didn't give us enough time. You had 48 hours at least. Actually, you've had this entire case to prepare for that decision. So in my humble opinion, the judge was more than fair. I think more fair than most people. In fact, he probably could have held a contempt at that point. So I don't know. I don't think it'll be enough. Yeah, we talked about that. What about Tom Petty sleeping on the trial day? Yeah. I mean, come on now, y'all. Come on now. Do you know what? We knew that an appeal was coming and it was going to be a bunch of spaghetti with poo in it, and they're trying to make something stick, and it ain't going to happen. In my humblest of opinions, and I'm not an attorney, I may be a criminal justice major, but I'm not an attorney. In my humble opinion, this does not warrant a trial, and it will not warrant a trial. I don't see anything that's strong enough for that. But if there was a new trial at all, or hope of a new trial, it's 7. Yep. We've seen some crazier things happen, haven't we, Angela? Georgia is losing. Yep. I bet she knew it was coming. She knows it's coming, and that's cool. I just really love that suit. I want to lose another 30 to 40 pounds, and I want to get me a power suit. My daughter's getting married, and everyone goes, you're going to get a dress? No, I'm going to suit. Get a real pretty suit. I like suit. It could be a skirt suit. It could, with pants. You can get the jacket, the skirt, and the pants. Yeah, that's what I'll do. Appeals is an automatic thing. State of confusion. You're correct. Well, yes and no. You have to file for it. It's not something that just automatically happens. You have 10 days to file the intent to appeal. Each state has its little difference. If you're Sarah Boone, oh God help us. But anyway, I had a wonderful spaghetti. I don't know what sauce my son got. He doctored it up. Oh, I could smell the garlic cooking in here, and I inhaled it. So good. I haven't had spaghetti in a while. Throwing spaghetti at the wall and hoping something sticks. Yeah, it depends on how well cooked it is. And the Markel family has been through enough. Oh my God, jury's trial, the ex-girlfriend in the Rivera. And then, they've had, didn't they do the killer and the girlfriend McBanua together? Then McBanua got another case, then Charlie Adelson, then Donna Adelson. That's 5 trials. No, wait. McBanua and him together, her by herself, Charlie Adelson. That's 4 trials. If Wendy goes, that'll be 5. But I think Wendy is a possibility, but I'm probably 40, 60 she will not. Yes, they will see it through the end, and we will too. Whatever they do, we will be following it. And I want to give everybody a special shout out for being so kind to me this last couple of weeks. It has been very difficult to leave my studio, our office. My home is stacked boxes this high everywhere. It's just a path to my son's room, a path to the kitchen, a path to, well, I'm working on it. I unboxed a few while I was here. Today we got the Rodecaster Pro. Pro 2 replays. It is new. I hope those who just hopped on, my sound is better. I got my second light installed, so I know my lighting is back on target. And so I'm happier as far as that. But I just walk in that living room and go, how am I going to do all this? It's horrible. I don't have room. But I have to go through. We're going to be doing a lot of garage sales on weekends. But anyway, Definitely think they're going to hang in there, and we'll do what needs to be. Yep, exactly. Hey, June, did you pick out a movie? Do we want to share with our peeps what the movie is going to be? If you haven't, it's okay. By the way, in our Discord, I've made some changes. We've got some cool stuff starting to happen. In the next week, I'm going to roll out a thing where special members will have access to certain things. I'm going to be visiting with our mods. We're going to decide on how to handle that. We're going to be making a members section, membership section. Those of you who are members to YouTube will have special permission. I don't know how. Someone have been asking to me about Patreon. I have a Patreon, but I have not done it yet. I'm not quite there yet. I'm going to start focusing on my memberships on YouTube, giving y'all some special access. So that's going to be happening. Give me a moment. This is the. Yep. She said, give her a moment. Oh, by the way, I found my Irish whistles. I found my native flute. I found my shofar. Anybody know what a shofar is? It's a ram's horn that they used in the Bible when they say blow the trumpets. It is actually this is what a shofar is. Isn't that cool? It's big. I got a big one. I got a little gold plate. Helps me hold on to it. But this here is a shofar. And yes, I can blow it. I can blow it, but it's quite loud. I don't think I will blow it because I don't want to blow your eardrums out. Members only stuff. Yay! Members only will be coming soon. So this is a shofar. Then I've got my Irish whistle. So who knows? I may do a live where I play my instruments. Who knows? Now that's not an instrument. That's just that's one of those kind of horns. So yes, members stuff. What do you mean? Oh wait, never mind. What do you mean? Wait, never mind. I'm waiting for Miss June, and once we know the movie, Miss June, no hurries, but we're good. I also want to thank the Bernie for the flowers went to the first responder appreciation for those who responded to the 4th of July and the aftermath floods of Kerrville, where I live. Went to an event. I got blessed. They gave me that. They also, where did it go? We have a wonderful challenge coin, which I normally don't keep them in these plastics because they're hard to get out, but I'm going to keep this one. This is a very special. I have like 30 challenge coins. This is a very special one. Look how beautiful that is. It says the Texas Hill Country flood, July of 2023. And on the back, praying for the Hill Country. Lord is near, brokenhearted. And maybe one of these days we'll do a challenge night where I sit there and members only live and show you all the cool stuff I got. I love my challenge coins. I love to get them. I'm going to get a challenge coin made. I've got to go by the store and get me an eye contact case. I just realized I don't have one. My other one has my old content, so now I need to get a new one. Nice coin, isn't it? But that one's really nice. I've got a few really. By the way, I do have a really nice one. And don't fuss at me. I don't want to hear anybody fussing. I don't care who your president is. I don't care if you like our president or not. But I got this. The letter of appreciation from Chip Roy. I got a coin from the House of Representatives. And then after I got it framed, the presidential coin came. So it was like, dang it. I put them both together, but it was already framed. So I can't. But I got I got that when I saved a family of 5 on the side of the road. Yeah, I know. Once in a while, first responders recognize. Boy, I didn't expect that. That was. Oh, somebody asked what was behind me over my shoulder. Somebody said they saw Santa Claus on Facebook. I showed y'all before. I have fallen in love with the Lego minis. Um, I, my children are Lego freaks, and these, actually bought these for my daughter, and then I got confused. I bought 4 of them for my daughter, and then the 5th one, that's how I found out about these. One of you guys hooked me up on Santa Claus, and I went and looked, and I ordered a set for my daughter, and then somehow they sent me extra. I only have one of the Santa Claus. I put it together for my daughter's. Her favorite one's a tree. So anyway, these, look at the micro mini. Look at them. If you guys have young kids, this is on, I think, who is it that has the page? Is it TikTok? Has the shopping where you can shop? Yeah, TikTok. Is it? Let me look. Yes, on TikTok you can shop. I didn't know that. So anyway, these are only like $2 a piece. And I got these for my daughter because she loves Legos and she's an adult. But I thought this is my favorite. A little, look at that. And then these, the Christmas tree. So if you guys are looking for a cute thing for grandkids or for kids that are not too young for these, was shipping $15 for all of them or less. So yeah, I absolutely love my little Christmas people. Do we have a movie, June? I don't know. I didn't see a reaction. No. Okay, guys, what we'll do is we'll pop a movie up and just go into Discord. Our Discord, go to members. And under members, you're going to see voice channels. And in voice channels will be movie night. And you'll be able to watch a movie. Okay. Once again, thank you, Rodecaster, for being a wonderful company. Even though my unit was 6 months out of warranty, you replaced this. Thank you so very much for being so amazing. Oh my gosh. Angela, love you, boo. Thank you so much. Yes. What is my Discord? Well, we popped it up, but I'll pop it up again. Here we go. There we go. I got it. Popped it up for you. There we go. There we go. That is my Discord. We watch movies quite frequently, 3 or 4 times a week. It's just a fun way to just kind of hang out, but not hang out. Kind of like we watch the movie, we can chat if we want to. I got to tell you right now, June is at 100% of picking badass movies. She has been amazing at picking movies. No pressure, boo. No pressure, none whatsoever. So anyway, it is 8:30 now. I'm going to go ahead and sign off. Oh, I'm into the logo botanicals. I have one, and I've not put it together yet. I might get into that much stuff, but I have nowhere to put anything right now. We have 2 of the big Star Wars, like $1,000 set of Legos that build these big ships. We got 2 of those. My kids each got one, and let me tell you, there's nowhere to put them. They're huge. The wingspan is like this. They're massive. My daughter moves it when she moves into her new house with her husband. When they get married and they move in, that's going with them. I'm tired of it sitting on my coffee table. Oh, the minis, they're on the TikTok. Give me a second. I don't want the sound. Guess I need to log in. Code. I got to log in with the code. Why is it waiting? Oh no, I got to do this puzzle thing to prove that I'm not. That I am who I am. 259634. 25. Five, 9, 6, 3, 4. Log in. Okay. Where's shops? Where's the shops? How can I not get shops? I hear you. I'll be there in a second. I can't find it. I tried. I wouldn't do that tonight. I'm not feeling that tonight, boo. I appreciate it. Here. There we go. Shop the TikTok store. Well, I thought it'd pop up the shop. Anyway, if you can go on your phone, click on the TikTok shops, type in mini Legos, and it will pop up. No pressure, June. I absolutely loved the Legos. Anyway, they're like only 2 something a piece. I wanted to show you, but it's okay. It won't let me. But maybe I can on the phone. See if I can find it. There they go, the micro mini Legos. So these were $1.90 a piece. Look at them. They're in the Kids Playville. That's what they're called. Kids Playville. And if you like the minis, I mean, they even have, oh my gosh, my sister would have loved it. They even have the sea animal. They have the sea animal. It is so freaking cute. Oh, Finding Nemo is cute. Oh my God, that's a cutie. But they have, here's the botanicals. And you guys, let me tell you, that is so cute. So anyway, go if you ever do TikTok, they have the micro minis and they are stinking cute. So there you go. Great gift ideas. Great gift ideas. The Nightbot said it expired for you. Are you telling me the link is expired? Let me go on and redo it. I don't know why it would be expired. I copied it. It should be fine. That's the new link. That's the new link. Click on the one that I just put. It shows that's the new link unless I have to edit. I'm going to put never. Okay, here's the new link. Here's the new link. It will not expire. There we go. I changed it. It won't expire. It's good until I change it. Okay. So our Discord people and all my background people and all my mods, this link is not going to expire. I don't know why it was set on 7 days. So you're good. Right. Yeah, because I changed the settings to where it won't expire. So you don't have to keep redoing it. Okay. All right, beloveds, y'all have a fabulous evening. Oh, wait a minute, Miss June. How about Sister Act? That will be fun. Sister Act 2, Back in the Habit. That'll work. We'll see that one. So that is going to be our movie for tonight. It's going to be a little bit of a comedy with Whoopi Goldberg and Sister Act. We will watch that one. Okay, guys, I got to run. I got to go buy me an contact case for the new ones. My old contacts are in the other case. I don't have another one. And I'm not sleeping in these, boo. So we'll see you guys. June, are you going to start that at 8:45? Is that good? Or 6:45 your time? Yeah? Yeah? I'm waiting for June's answer, and I'll let you go. But I hope y'all enjoyed the dive into this motion hearing. Once again, I'm not a lawyer, but I try my best. Oh, thank you so much. Thank you. State of Confusion. I really hope that you can join us. And Linda, I hope you can join us too. State of Confusion. I'd love for you to reach out with me. Reach out to me, private message in Discord, please. All right. In 15 minutes or less, we'll be in a movie. And I'll be back hopefully by then. All right, guys. See you in a minute. Miigwech. Otherwise, we'll see you first thing at 8 o'clock Central Time for the Jose Antonio Soto Escobar, whatever, trial. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.